Welcome back, everybody, to our studies in public law, or sometimes referred to as constitutional and administrative law. In this lesson, what we're going to do is move on to the second half of our major topics. This is going to be the part of the series where we start to examine administrative law. So when you study constitutional and administrative law, it is divided into two subjects. You have the constitutional law, the law of the UK Constitution, all the various principles therein, all the various ideas, and then you have the administrative law, which is often tied up in and around two major topics. So firstly, we will be talking about judicial review, the grounds for judicial review, the process by which judicial review takes place, and then we will talk about the second major topic, which is that of police powers and public order legislation. Those are the two things that we're going to examine in this next few lessons. In the last of these lessons, which is probably about 20 or so videos, that should be encompassing all of these different topics. But for now, though, what we're going to do is take an introduction to administrative law. We will examine what administrative law is, and we will talk about the process by which jurisdiction is given to the High Court to rule on issues of administrative law. So what is administrative law? Well, broadly speaking, it is the area of law which governs the executive branch, their departments, and their agencies, specifically the ways in which they act in application of and in the enforcement of the law. Now, administrative law is an area of law that is broad and all-encompassing in and of itself, and it is probably likely that in the future we will do a series of lessons specifically talking about administrative law. But for now, the area of administrative law that is most important for public law scholars is in relation to this idea of judicial review. Administrative law is most often adjudicated through the process of judicial review, at least when it comes to the quite high-end, quite significantly debated public law questions that are examined. Often we are talking about judicial review. So then this begs the question, therefore, what is judicial review? We know what administrative law is. It is a law that is examining the process of the executive branch, the government of the governing the executive branch, the departments and their agencies. What then is judicial review? Well, judicial review is the process by which we can think about holding the executive branch to account. It's a way in which we can hold executive power account for their actions. And this doesn't just include the executive branch in terms of the ministries, the departments of state, and the government ministers that exist therein, but further than this, it can represent any kind of public body that can be the subject of judicial review, which we'll get to in the next lesson. The subject of judicial review includes, in fact, any public or private body carrying out a public and exercising public functions. So for the most part, we are concerning ourselves with public bodies, okay? And we'll get to, like I said, in the next lesson, where we'll examine how this is actually determined. But it could even be private bodies that exist, but that they are carrying out and exercising public functions. So whether or not they are defined as a public or a private body isn't the only consideration that we have to think about when examining the ways in which we can exercise judicial review against that particular institution. The process here is for a court, usually the High Court, or in addition to this, any kind of appeals court on appeal from the High Court. They examine and come to a determination the lawfulness of a particular decision, which has been taken up by a government department, a local council, or any other public body and or private institution that is carrying out public functions. This is essentially what judicial review does. Now, the High Court is a very interesting institution when it comes to judicial review, because what the High Court has is this thing known as supervisory jurisdiction. And this is really where judicial review originates, and really, or at least where it derives its authority. It means essentially that it has the authority to hold the executive branch to account on the basis of the lawfulness of the actions that they may take. This supervisory jurisdiction has constitutional basis in the principles of the separation of powers, as well as principles related to checks and balances and the rule of law. So one of the things that is often not cited in the textbooks on constitutional and administrative law is the ways in which these two subjects actually interrelate with each other. The ways in which public law, broadly defined as constitutional on the one hand and administrative on the other, actually integrate with each other. People tend to just, or the textbooks tend to just go and spend a lot of time talking about the UK Constitution, and then they'll just move on and talk about judicial review, and they don't really explain and analyse the ways in which there are interlinkages between the two of these subjects. This is one of the ways in which we can understand this. When we think about the idea of supervisory jurisdiction, it has a constitutional foundation. It has foundations in constitutional law, such that constitutional law simply represents almost the basis, the foundations for which we can get judicial review and administrative law, such that administrative law is born out of constitutional principles. The constitutional principles that we are thinking about are things like the separation of powers, things like checks and balances, things like the rule of law. Fundamentally, the basic principle of the rule of law is that the government authorities should not act outside of the law. Indeed, in addition to this, they should not act beyond their authority, all of which is great, and it makes sense to suggest that this is a basic principle of the rule of law. But how is the government, i.e. the executive branch, actually held to account if there are allegations made to them or against them about whether or not they have acted beyond their authority? Well, this is where judicial review comes from. If you want to make an allegation of judicial review, or an allegation of illegality, for example, or acting beyond their authority in relation to a government action, then you can bring a judicial review claim, and it is up to the judiciary to check the authority and the power of the executive branch. And therefore we get some principles of checks and balances, and we get principles of the rule of law in relation to the relationship between the judiciary and the executive branch. And the legislative branch obviously plays into this as well, given the fact that a lot of the authority that is granted to local departments, to local authorities, and to government and public institutions and public bodies derive from statutory authority and delegated legislation. And so as a result of which, and as a result of that, the legislature also has a certain amount of impact and influence over the ways in which the executive make decisions as well. So we're thinking about actions which may be beyond their authority, and this gives us the first basic principle of the idea of judicial review, which is known as the ultra vires doctrine. We'll talk about the ultra vires doctrine in future lessons' time, but fundamentally what ultra vires essentially asks us to do and to examine is whether or not a government department or a public body has actually acted beyond their authority. They may have a certain amount of authority and a certain amount of discretion and discretionary power that has been most often enshrined onto them through the implication of legislation, through statutory or delegated legislation. And so if they act beyond what is prescribed to them through delegated legislation or through statute, then they are seen to be acting ultra vires. And so what we see here is that the supervisory jurisdiction of the High Court allows for the government to be held to account and to therefore ensure that they are conducting their own actions and they are conducting their own conduct according to law, the law for which they have the authority to be able to conduct themselves in the way that they do. So in the previous lesson, we talked about the introduction to administrative law on the one hand, and in this lesson what we're going to do is talk about judicial review in a little bit more detail. So we touched on judicial review at the end of the previous lesson. We noted that one of the main ways in which we can see the imposition of, or the expression of administrative law is through the idea of judicial review. We also noted that the supervisory jurisdiction of the High Court gives the idea of judicial review a certain amount of authority. The constitutional nature of judicial review essentially allows for the upholding of basic principles of the rule of law. And in addition to this, we can come to the conclusion that what judicial review fundamentally is the ability for the courts to hold the executive branch to account, to hold executive authorities, whether that be departments of state or whether that be other public bodies, to account for their actions to ensure that they are not acting beyond their authority. This is known as the ultra vires doctrine. This lesson is going to essentially go into more detail on the subject of judicial review, as well as concern ourselves in the grounds for judicial review, which is going to be the main subject of the next few lessons, where we talk about things like illegality, irrationality, and procedural impropriety. This lesson is going to spend some time taking an introduction to the subject, as I noted, looking at its purpose and the necessary requirements for bringing an appropriate claim of judicial review in England and Wales. And the first thing that should be noted here is that judicial review can only apply to particular defendants. It can only apply to particular instances, specifically public bodies. So we noted that this is the first point of reference, that when we think about who can be subjected to a judicial review claim, the answer to that question is that it must be public bodies. They are the only institutions which can actually be subjected to a claim of judicial review, or in circumstances where it is a private body but they are performing and exercising a public function. And so what this means, therefore, is that when we think about judicial review and the potential claims being brought against certain institutions, we have to examine the nature, the purpose, and the functions that those institutions actually carry out in order to come to a determination as to whether or not it is going to be a successful judicial review claim. A public body simply refers to an institution which carries out public work. Public work generally refers to work which has an effect onto a general population. It doesn't necessarily have to be the general population in its entirety. It could be a specific subset of the population, such that it is a specific subset of the general population. It could include a variety of different institutions. It can be and is not limited to government departments on the one hand, so for example the Home Department or the Department of Foreign Affairs. It can be the ministers of those departments, so the Secretary of State for Education, for example, the Secretary of State for Immigration, the Secretary of State for the Home Office, the Home Secretary, all of which can find themselves in the light of a judicial review case. It could also refer to local authorities as well, again performing performing executive functions or performing public functions. Now, the case of Crown versus the Disciplinary Committee of the Jockey Club is one such example of where the courts have been invited to examine what it means to be a defendant in a judicial review case. This case concerned an example of which kind of institutions could be subject to judicial review, and it gave us an indication as to how this is determined. Was firstly the disciplinary committee of a jockey club able to be subjected to a claim of judicial review? Did it fit the bill for being a successful claim in judicial review? Well, the courts concluded that when deciding whether or not an institution is able to be subjected to judicial review, obviously we have to therefore decide whether or not an institution is a public body. In making this determination, there are a number of considerations that have to be examined. These considerations include the nature of the institution. It also includes the origins and history of the institution, as well as the constitution and membership of the institution. There needn't be an institution which is controlled by the government or the government authority necessarily. So this is something that should be subjected to a case-by-case analysis. Now, in addition to this, questions that also need to be asked is whether or not the body has been integrated into the system of statutory regulation, or potentially if it is carrying out a function which is ordinarily the remit of government, or even if it is performing some action that would be performed by an organ of the government if this institution did not exist. These are the kinds of questions that, when subjecting an institution to a case-by-case analysis, we come to the conclusion of whether or not they can be subjected to a claim in judicial review. Now, as a basic spoiler alert, the conclusion in this case was that the disciplinary committee of the Jockey Club was not considered to be a public body, and so the courts concluded that a judicial review case could not be brought against them. One of the things that's very important to note is that when bringing a case of judicial review, it's very important that we do not abuse the process, and in fact don't find ourselves in circumstances where we are being accused of an abuse of process. Once it has been determined that the body in question is a public body, then it must be determined that the action in question was a matter of public law. That is the next question. If it is not, then the claimants who brought the claim could be guilty of an abuse of process. In addition to this, if the matter in question is a matter of public law, and if the body in question is a public body, then it would also be an abuse of process to bring an ordinary claim of litigation and not a specific judicial review claim. So if it is the case that we are talking about and dealing with a public body, okay, if it has been determined that it is a public body, and if it has also been determined that the matter in question was a matter of public law, but instead of bringing a claim in judicial review, we decide to bring an ordinary claim in civil litigation, this will also be considered to be an abuse of process. The reason for this is because it would suggest that the claimant is trying to gain an unfair advantage throughout the process of bringing about litigation. Essentially, there are certain rules in place which protect a public body in certain judicial review cases. These rules in place, these protections in place, do not necessarily exist in circumstances where we are talking about an ordinary case of civil litigation. So basically, there are specific things in place which are essentially tailor-made for circumstances of judicial review claims. So it would be an abuse of process and essentially a claimant trying to gain an unfair advantage if they could have brought a judicial review claim, and it would have been most appropriate to bring a judicial review claim, but instead they do not, and they instead go for civil litigation as an alternative. In this lesson, what I want to do is spend a little bit of time talking about the process of bringing a claim in judicial review, talking mainly about the claimant in a judicial review case, who that claimant can be, and what relationship to the alleged violation or the alleged acting outside one's authority that a public body is actually doing, and what relationship they have to that public body, or to the particular circumstances in question. So, the previous lesson spent a little bit of time looking at the concept of judicial review, looking at a number of the major requirements and some of the key elements in the process of judicial review, such as this idea of abuse of process. The idea here being that if you are a claimant who has a valid claim in judicial review, it would be an abuse of process to bring an ordinary piece of civil litigation against a public body, because there are certain procedures and requirements and that there are certain protections in place for public bodies in judicial review cases that don't exist in the ordinary instance of civil litigation. So this lesson is going to talk about the process of actually bringing a claim in judicial review, the person who may be a claimant, and looking at a couple of pieces of case law that illustrates the purpose of this particular area, the purpose of essentially restricting, at least theoretically restricting, the number of people who may be and may be able to bring claims in judicial review. So I've written here that theoretically, anybody can bring a claim in judicial review. Now, while that is true, what I mean by this is that theoretically there is no limit to a person who has a valid claim in judicial review to bring a claim in judicial review. But in reality, the judicial review pre-action protocols stated that a person can bring a claim in judicial review so long as they have a sufficient interest in the matter in hand. So when I say theoretically anyone can bring a claim in judicial review, what I mean there is that any person could bring a claim in judicial review so long as they have the prerequisite sufficient interest in the matter. Now, this does limit, as a result, therefore, the number of people who may be a claimant in judicial review cases. If you do not have a sufficient interest in the matter, you do not have sufficient interest in being able to bring such a claim in judicial review, then you cannot bring a claim, and the claim would therefore fail at that early juncture. There is also the ability, if you are maybe not somebody who has a sufficient interest, you may be someone who has an interesting party, and therefore you may then be able to bring a claim in judicial review along that particular merit. An interesting party is defined in the civil procedure rules as simply a person who is not the claimant or the defendant, who is instead directly affected by the judicial review decision. So this is the two general instances where an individual may be able to bring a claim of judicial review forward. Now, a key case which illustrates this point is the case of Crown versus the IRC, the National Federation of Self-Employed case from 1982. This case gives us an indication of the kind of thought processes and the kind of reasoning and rationales that a court will engage with when it comes to bringing a claim and when it comes to who may or may not be a sufficient interested party in the bringing of a claim in judicial review. This case involved a number of print workers on Fleet Street who had been granted a tax amnesty by the Inland Revenue on account that they registered their taxation affairs. Now, the National Federation of the Self-Employed, which was a union for self-employed individuals, brought a judicial review case on the basis that Inland Revenue had actually acted ultra vires in being able to grant amnesty. They brought the claim suggesting that they had acted beyond their authority in being able to grant this amnesty to these print workers on Fleet Street, and so the claim was to be nullified or to be made void. The question then hinged on standing, whether or not, specifically, the National Federation of the Self-Employed were able to bring a judicial review case on account of them having a sufficient interest in the case, or being a sufficiently interested person such that they were able to bring a case forward. Did the National Federation of the Self-Employed actually have the ability to even bring a case in the first place? The House of Lords held that the National Federation of the Self-Employed did not, in fact, have a sufficient interest and therefore could not bring a claim. Lord Wilberforce considered that the question of standing, the question of whether or not you are a valid claimant, and the question of sufficient interest ought to be considered in conjunction with the facts of the case, and that this would ultimately give a bit more of a substantive framework to the ultimate conclusion of a judicial review. It was held that Inland Revenue had actually not acted outside their authority, and so on this basis as well, there was no standing for the National Federation to even bring a case in the first place. So Lord Wilberforce considered that the questions of a matter of fact as to whether or not you have a sufficient interest also hinges on and also is determinative on the basis of the conclusion that would ultimately be arrived at in relation to judicial review. Lord Wilberforce says, quote, "As a matter of general principle, I would hold that one taxpayer has no sufficient interest in asking the court to investigate the tax affairs of another taxpayer or to complain that the latter has been underassessed or overassessed. Indeed, there is a strong public interest that he should not on this principle apply equally to groups of taxpayers. An aggregate of individuals, each of whom has no interest, cannot itself have an interest." So essentially what we see here is the extrapolation, firstly, from the point that it seems as a general principle that one taxpayer shouldn't have an interest in another taxpayer, and to then extrapolate that to an aggregate of taxpayers as represented by the National Federation that also does not make a sufficient interest in the general affairs of another individual taxpayer.